Hello, everyone, and welcome to the PCI Practical Matters podcast, keeping you up to date on important topics in government contracting. Today's topic is Top 10 Mistakes in Contract Administration, and our speakers are Fred Geldon and Tyler Evans.
Hey everybody, this is Tyler Evans at Steptoe and Johnson, and Fred as well. And Fred, in a second, you can introduce yourself. But I have been in government contracts for about 11 years now, and half of my work is usually in the defense space, and about half is in the life sciences. But had an opportunity to look at a lot of interesting issues. And Fred, as he can tell you, has been in this for a very long time and has a great many insights to share. And so today we just thought it'd be great to go through some of the common mistakes that we see in our practices.
Thanks, Tyler. Yes, I've been in it for quite a while. Started when my hair was actually dark. And probably, although I'm currently, along with Tyler, a government contracts in the government contracts practice at Steptoe and Johnson, probably the main area where I worked on contract administration was when I was in electronic data systems. I was there for 21 years, most of the time managing the contracts and legal group and getting into many of the mistakes that we make. And even though we had an experienced group of contract administrators, we still made a lot of these mistakes and had to learn from them. So let's get started. Just kind of as a preliminary thing, while Tyler and I have experience mainly with government contractors rather than the government side, much of what we're going to talk about really applies both ways. This is not a zero-sum game. Good contract administration benefits everybody. It helps the government programs run well, the government achieve its mission, as well as the contractor do well, not lose money, make money, etc. So it's very much we want win-win situations. And let's start, Tyler, with one of the basic mistakes, you might say the granddaddy of all, and that's the contract itself. Very often contractors will compete very hard to win the contract. They'll look very closely at the relevant parts of the solicitation that describe what has to be in the proposal and so on. And then after award, what happens to the contract? Does it sometimes just get stuck in a drawer, and does that matter? What's been your experience with that?
Yeah, Fred, I think that absolutely is something that we see all the time. And that's kind of absolutely, like you're saying, stuck in a drawer or just not read, right, the relevant sections, that kind of thing. And I think what happens is people get in this mindset of, well, we'll read the statement of work, that's really what's important in our contract admin, and that's how we're going to be performing this contract. And the list of FAR clauses from the Federal Acquisition Regulation and agency supplements, that's there for the lawyers, right? They'll handle it. It will be fine. Or if we have these kind of detailed full text clauses that go on for 10 pages about cybersecurity, well, I'm sure somebody will figure that out, right? Somebody on the team has to be doing that. And I think more often than not, we see that each person was kind of assuming the other was doing it, or they just, never really looked at some of these key terms. And it can really matter, because we'll go through today, I think, kind of how you often want to preempt contract administration issues, but not understanding the basic terms of what is in your contract, I think, is often kind of the starting issue.
And what about those pesky FAR clauses? I mean, they're all the same, right? We don't have to worry about whether there are new ones in there, because they're all boilerplate. Do you encounter that with you?
Well, I think you know the answer, Fred, that I think absolutely not, right? Each one is different. And over time, you can get familiar with them, right? And you can kind of somewhat remember what they say. But even ones I work with every day, I go back and I double check to make sure I understand them, because they're very long, very technical. And then there are also issues of just they include a new one because it's a different type of work, it's a different contracting officer, and then even at times different years, right? They've updated it and there's a new rule that you might not be familiar with. And so I think all of these clauses are very important to kind of look at. What I will say, though, is I often kind of say on practical guidance and not legal advice here, just kind of summary of what we've done in the past, but practically, I often kind of tell people, well, maybe look at the ones that look key or different if you're not going to read them all, or if there's going to be an issue, then start looking at the clauses when you're first kind of starting to get into it, that kind of thing. Obviously better to read everything up front, but doing something is better than nothing, I think, in some of those instances.
Yeah, let me supplement that, because sometimes, as Tyler said, you have to kind of reread them. Often you're dealing with the terms in a contract, with what we call the T's and C's, the terms and conditions, And you're focusing on the ones that matter in the context in which you're looking at it. Down the road, the same clauses may matter, but it may be Part D instead of Part C or Part B, which maybe you never looked at in the beginning. It's in effect, it's a new clause you haven't read, or it may just be a clause that you didn't have to deal with until something's changed, and you're now in the middle of the contract. Some events have happened, some changes, constructive changes, whatever, and all of a sudden there are clauses that didn't matter before, so you didn't read them, you didn't pay attention to them. Now you need to. But Tyler, you mentioned something about the clauses change, they're updated. How does that work? Which clause, do contractors have to be familiar with every update and then substitute the new clause in their contract when it changes?
No, Fred, they don't. And so generally the rule is it's kind of whatever is set on that date. If it says, disputes 1998, whatever it is, that version of the clause, that year will apply at the outset. And that's what's kind of set in stone, unless the parties agree to update the contract. Maybe you'll get a new task order and that's another contracting opportunity. There's a modification with another contracting opportunity, something like that. But otherwise, your default rule is what is in your contract controls. You don't automatically update the clauses with each update to the Federal Acquisition Regulation. And we see that all the time, I think, on the subcontracting side as well, where people will think it's good practice to update the clause, and maybe the clause has actually become more lenient over time. And so you should be harsher on your subcontractor and you're not realizing that, right? So for example, monetary thresholds and things like that. And I think the one caveat to all of that is monetary thresholds are, I guess you could say, kind of the one exception to all of that. I think it was back in 2018, something like that, but they did change the rules to say there's an inflation process in the FAR. And so when you say $150,000, do this, that kind of thing, those thresholds you can update and do get updated automatically, but that's a relatively recent development.
Right. Well, and there's another, you could call it exception, which is that contracting officers are permitted to substitute new clauses in if they choose to, even though it wasn't in the original contract. But when they do that, it has to be a contract mod. If that change might affect the contractor's cost or schedule, then there has to be appropriate consideration. And sometimes that's directed by the statute that led to the original update of the mod. Sometimes the the Defense Acquisition Reg or whatever will or statute will say this has to apply to all contracts that have already been awarded, and then that's mandated as a change, again with consideration where appropriate. Or sometimes a contracting officer could simply say, I'm managing a lot of different contracts. I want them all to have the same government property clause, so I don't have to worry about dealing with, gee, this is a contract, now which clause is in, and take time to do that. Again, they're permitted to do that, but it doesn't, as Tyler said, it doesn't happen automatically. What about the things that are not in the contract? If a clause, if there's a provision that isn't in the contract, is there ever a time when it still might be applied, that still might be there somehow?
Yeah, Fred, I think it's a good
question.
Yeah, exactly. It's a good question, and the answer is yes. And I think the lawyers listening in might immediately think of the Christian doctrine, which we can talk about. But just generally, there's that and some other principles that anybody should keep in mind, I think. And essentially, the issue is that the kind of standard response to this type of thing is that there is a doctrine out there that's applied in government contracts called the Christian doctrine, which basically says anything that's really important to government contracting, a long-standing principle like termination for convenience or something like that, will be read into the contract because it's in the Federal Acquisition Regulation, something established by law. But I think the tough part about that, Fred, is there's no clear line, right? You have to kind of go in case by case, clause by clause, see if it's been decided before, that kind of thing. Is government property the key to acquisitions? Is equal employment opportunity? All those types of things. But I think even beyond the Christian doctrine, you have just purely things that apply by operation of law outside the Federal Acquisition Regulation. And so I think that's something that I see maybe more often and is often even more relevant to a lot of contractors, where maybe you have a different agency managing a particular issue. So Small Business Administration on small business issues, or the Office of Federal Contract Compliance programs on labor issues. And sometimes they say their regulations apply by law no matter what's in your contract, right? So you might be dealing with that kind of issue. And so I think you just have to keep in mind that you're governed by a number of things as a government contractor. even if they're not in your contract. And that might be because of this principle, the Christian doctrine, or it might be if there's another statute or regulation saying that government contractors have to do X.
And let me just, for those on the call who are listening in, don't get so scared about the Christian doctrine that the government can do anything it wants. There are some limitations. It really only applies if it's a mandatory clause that the contracting officer neglected to put in. It's not something that can just be picked and chosen from anything that's out there. And I should also add that it's not a religious doctrine. It's based on a case that was involved a company whose name happened to be Christian, but there's no theological aspect to it. All right, Tyler, do you want to kind of move on to the next area?
Sure. Yeah, so we can get into the next kind of common mistake after looking at not reading the contract. And I know, Fred, you sometimes like to talk about rules, requirements, and rights, the 3 R's. So what are those? Maybe start with rules.
Well, rules, that's really the way the government has structured how contractors should act, and in many cases, how contractors can protect themselves, make claims when there are disputes, when there are issues that come up. They're not always intuitive. They're not always in the contract. They're really governed by the FAR and in some cases by statutes. The FAR is the roadmap, and contractors need to be aware of that roadmap. It's worth noting the FAR itself speaks mainly to the government side, mainly the government players. You might think of it as a user's manual for contracting officers and others on their team. But it's critical for contractors to be aware of what the people on the government team can do, what they must do, what they're not allowed to do, what the criteria are for doing things, what's allowed, what's not. I have a former colleague, Michelle Williams, who used to say, dealing with the government, doing business with the government is like playing poker, except the government holds the high cards. But the good news is that the cards are marked, and the marking is the FAR, and the contractors have to be fully aware of that. That's the rule side. The requirements side is really following up on what we talked about earlier with the terms and conditions. Most of the time, contractors are pretty good about making sure they understand what the statement of work is. We'll get to some issues that concern that later, but at least as a starting point, it's fundamental to the bidding process. And then once you win the contract, it's fundamental to performance. What isn't always paid attention to are the T's and C's, terms and conditions. They're viewed as Tyler noted, as you noted, something the lawyers should worry about. And yet, in many cases, they really are just as fundamental as the statement of work. They govern what's going on, the funding. They govern what the government can and can't do on changes and on constructive changes. Or here's a one that I've seen overlooked too many times: limitation of costs. If a contractor has a cost contract that is approaching a certain percentage of the cost ceiling, and there's always a cost ceiling, it needs to provide written notice to the contracting officer. And way too often that doesn't happen, not because of a deliberate omission, but because the parties are working together and it's viewed, well, everybody knows where we are. Well, contractors can get into real trouble with that. We had one instance where we had discussed the cost ceiling and approach to it at an actual meeting with the government. And believe it or not, the government's response when they claimed that they hadn't gotten proper notices, the contracting officer who was in that room was asleep. You got to put it in writing.
And Fred, so on the rules and requirements, maybe putting those two together. And at the outset, we said, this is for government personnel as well as contractor personnel. One thing of a requirement, if you just think about, well, what's in the FAR that might just be applying kind of in the background, or it's in the clause, but it's not something you're thinking about when you're looking at the statement of work, like the notice of limitation on funds. The one that I always find very interesting is the government obligation to provide notice of an option exercise. That's a good one where it can be problematic for the government and the contractor maybe get some rights. Could you maybe speak to that a little bit?
Oh, I'd love to. The option provision provides that it's the government, not the contractor, that has the right to exercise an option. But the contractor has to, the government contracting officer has to provide notice a certain number of days in advance that it intends to do so. And that notice is not binding. So experienced contracting officers will generally provide that right at the beginning of the contract or the contract option period, and then they've got themselves covered. And down the road, if they decide to exercise the option, they're covered. And if they don't, that's okay too. They're not bound. But sometimes contracting officers miss that. They don't provide that notice. And then you get an interesting situation. The contract period is about to end. The contracting officer says, whoops, I didn't provide notice, but I want to extend the option. And now the contractor has rights that it normally wouldn't have, namely the right to say yes or no. If the contract is going well, it may say, fine, the notice requirement that you missed is no big deal. But it has the right to say, well, you know, we're not making so much money, maybe we're losing money, or maybe we're just greedy and want to take advantage of the contracting officer's failure to put notice in, to give the notice. And so we're not going to accept that extension unless you make changes to the contract price, for example. Contractors well within their rights to do that, but I would counsel very strongly about making sure you think that through before you do. And the reason I say that is because most government contract disputes are not personal. They involve the parties interpreting language differently, or trying to prove costs and making sure that they were done, and a lot of things that don't really get to personal mistakes. They get to different interpretations. But failing to provide the required notice is an unforced error, and if a contractor takes advantage of it, they're basically undermining the contracting officer. That contracting officer is going to be going to their manager and saying, the manager is going to say, okay, did you extend the contract, exercise the option? And the contracting officer will have to say, well, there was a problem. And the problem was, you know, their fault. But you're probably not going to be you're probably going to be taken off that contracting officer's holiday card list. You know, you're affecting the relationship. I had that happen when we were at EDS. When I was at EDS, we had that happen with a contractor who was in a different contracting officer who was in a different agency, but had a long-term memory, and something my predecessor had done was bouncing back.
And Fred, I think that the one thing I would add on top of that, though, based on some interesting things I've seen in the past, is sometimes that bridge is already burned, right? And so my favorite example is a dispute that was heading towards a breach kind of termination for default type situation for a contractor, and they still wanted part of the contract to be performed, not the breach part, you know, that kind of thing. And there were a lot of negotiations, and an option exercise was missed, and essentially that was the basis for a settlement, you know. And so it's definitely, I agree with you, but you know, sometimes you just have to kind of go that way. And I guess you know, it's interesting because when we get to the third R, the rights, I know we've talked about this a little bit as well, but Fred, you know, everybody always kind of hears that quote from Justice Holmes, right? That you know, contractors have to turn square corners when working with the government. And I think I always prefer Justice Jackson's follow-up that, you know, there's no reason why that shouldn't be a one-way street for the government, which is what we just talked about, right? But what are some issues in the rights category that you would think of for contractors?
Well, a lot of it involves notice, as we said before, notice of contract changes, especially constructive changes, notices of delays and excusable delays. And let me flip that around for a minute, because when a client comes to me, when a contractor comes to me and says, how should we handle this? I'm generally going to be giving the most conservative advice to protect the contractor from the various kinds of mistakes. Yes, you should turn square corners, even if there might be an argument that you don't have to. But then if the contractor comes later, not before they've taken the action, but afterwards, and says, I should have asked you, or maybe I just didn't follow your advice, I don't say, gee, I told you so, or nanny boo-boo, you're out. Rather, look to see situations where maybe it's the government that also didn't turn square corners. And maybe there's a waiver argument or an equitable estoppel argument, or there have been cases involving the government breaching its duty of good faith dealing and fair dealing. Things where yes, the contractor made a mistake, but it doesn't have to give up before looking at those questions. Now, that doesn't mean that every mistake is going to be curable that way. It may be that, you know, there's a mistake and you just have to live with the consequences, and that's it. But before doing that, before just giving up, it's usually worthwhile looking to see if there may be some arguments the other way. All right, are we ready to move on to the?
Yeah, I think let's move on to the next set of mistakes, Fred.
Okay, this is a fairly common situation, and that's the authority that the government has or doesn't have, or government players have or don't have, to make contract commitments. How would you describe that, Tyler?
Yeah, I mean, I think that's kind of one of the key principles in government contracting that everybody hears and then immediately forgets when it comes to contract performance, right? And that is that a warranted contracting officer literally has a warrant, has a official document saying that they can enter into contracts up to X value or unlimited value, whatever it is the only agent that has authority to bind the government. There's no such thing, if you want to look at it from a legal perspective, of apparent authority against the government. So if somebody goes out and I'm holding them out as a company as my vice president and they didn't really have signature authority, but it kind of looked like they did, most companies are held responsible for that. And in the government, no, it's the rule is essentially, it doesn't really matter if you weren't aware that there's lack of authority, you have to deal with a contract officer when you're dealing with something that's official, such as a contract change.
So what can the contracting officer's representative or quality control guy, what can they actually do?
Yeah, so that's what's always interesting about this relationship is it really depends on the agency, but sometimes you have the contracting officer just kind of sits in the background only handling contract mods, or is even add another component of the agency, right? You have that with Army Contracting Command doing work for others and things like that all the time. And a lot of the performance still takes place through the contracting officer's representative, the core, the contracting officer's technical representative, the COTR. And in both those instances, yeah, they have authority to talk about kind of technical direction, what should be going on, quality standards, things like that. But if you're dealing with final acceptance, final decisions on things, it has to go to their contracting officer. And so if everybody's working together closely with the core and the core agrees the program has to go in this direction and we have to make this change, accelerate, whatever it is, you always kind of need contract officer approval for that. And that's why it's good to always have kind of a set practice in contract administration of always following up by email, always following up with minutes, whatever it is, and copying the contracting officer. You can always request confirmation. Sometimes you don't always get it, but at least having a knowledge kind of component to it is sometimes helpful in disputes that arise in this area.
And another helpful way to try to structure this is to have somebody on the contractor team who is going to be the conduit for any contractual issues or negotiations or changes. At EDS, we had a whole group of contract administrators, and it was their role to play the same kind of role that the contracting officer did. Now, we didn't have the authority of law to say that no one else could be bound. As you said, there's a apparent authority, the doctrine of apparent authority, and so there were other players who could be binding the company. But as much as possible, we tried to make those commitments through a single individual to try to keep control over that. And we were blessed that most of our business leaders were savvy enough so that if they did make a commitment that would bind the company, it was usually pretty wise. Didn't have major problems with that. What about contracting officers and cores who don't always talk to each other? Have you run into that?
Yeah, I think absolutely, and we're seeing that more and more. And again, when you have I always call them contracting shops, right? A component of the agency is set up to do contracting for many other components. And that, in that case especially, but even in cases in which they're in the same agency component, you have the contracting folks maybe not staying on top of what's going on the technical performance side. And that might simply be they have a lot of contracts to administer, right? It's just kind of a resources issue. But that can happen, and that's where we're always kind of talking about, no, you need to loop in the contracting officer to bring them in to make sure they understand where things are going if there's a change, because that preserves the contractor's rights. And it also makes sure the government doesn't kind of end up in a dispute that it wasn't intending to. The contracting officer can correct that issue if the contracting officer's representative was acting out of line or anything like that. And then I think the other thing to keep in mind is in those situations, from a practical perspective, it's always great to have the written, I confirm and agree from the contracting officer. You won't get that for every single little issue. And so there does have to be practically a little bit of flex where the company, I think, typically realizes that not every little decision is approved by the contracting officer, but it has to do that with eyes open, that it might not be able to claim that there was an issue later on if it comes up. And as long as that's communicated internally, I think that's a fine strategy as well.
And sometimes the way to handle that is to say, we understand that the requirements are X or that your direction is Y. Please advise if otherwise we're planning to act on that basis unless you tell us otherwise. Kind of
Exactly.
a negative tip-off to try to do that. Because you're right, if you do something that is making the program shop happy, but not necessarily authorized by the contract shop, you may get a happy customer and you may get a thank you for being a volunteer and doing something at your own expense in the interests of the government. And while that may be admirable, it's not particularly financially advantageous. A lot of times, in my experience, the contracting officer and the core, or the COTAR, as we used to call them, were not really effectively communicating. One would think that the contracting officer's representative would talk to the officer. I mean, representative should mean something that way. But sometimes they're not only in different offices, but they're different cities, and they have different clients. The contracting officer is going to want to make sure the contract is followed, that the the financial aspect is doing right, and basically want to enforce the contract as it was finally awarded. And the program shop is looking much more toward the mission and what they need to achieve the mission, and maybe what they originally wanted when they first proposed that there be a procurement, and what was ultimately considered best value in the decision by the source selection authority may not reflect everything they wanted. And so sometimes the contractor's caught in the middle and has to be very diplomatic about saying, we want to help, we want to meet your expectations, we want to do what you're asking, let's go get the contracting officer on board. Because as you said, if you simply work at risk without doing that, with your eyes not open, you're going to find yourself losing out.
Exactly. So I guess, Fred, going on to the next common mistake, and this one comes up all the time in a variety of contexts, I think, is what happens, somebody just doesn't document their decisions. Earlier you said, well, you better confirm that by email, right? That the person was asleep when having this communication. But just more broadly, for both contractors and then on the government side, contracting officers, what's the importance of documentation here?
Well, the importance of documentation, I call it the first rule of government contracting, that it's not enough to do what you're required to do, but you have to be able to demonstrate, to prove that you did it. And that's true for both government and contractors. Contractors may face audits, they may face challenges in other ways, and they can't document what they've done, they don't prevail. Contracting officers may face protests, they may face IG questions, any number of things. A good example of that is the contractor purchasing system review, which was something that our company went through on several occasions, and at first not successfully. And the reason was that even though the business teams were doing the right thing when they brought contracts, vendors and subcontractors on board, they weren't failing to do the requirements, but they also weren't documenting them. So when the auditors came in and said, okay, show me how you did price competition, show me how you made sure they weren't on the excluded parties list, whatever the requirement was, at best they could say, well, I remember I made some calls and got some pricing, and none of it was documented and none of it passed muster. And we actually lost our approved purchasing system and had to really scramble hard to go through a very intensive documentation progress. In fact, if you buy me a couple of beers and have a couple hours, I'll tell you some of the horror stories that led to. But it is critical to document. And I say that as being somebody who's not comfortable documenting, or at least not, I shouldn't say comfortable, not very well self-disciplined on it, but you have to be.
Yeah, and Fred, I think the consequences are often very serious on a lot of those things. You're saying that you might lose your contracting purchase system review, that kind of thing. But some of the issues I've seen are disputes that come on later on about whether something was a commercial item and whether the contractor was flowing down the appropriate clauses, that kind of issue. And if something comes up that's serious for the government later, that was a breach, and the contractor defends saying, well, it was commercial item subcontract, we didn't have to do X, Y, Z, that kind of thing. Definitely not having the documentation of the rationale, even if the government disagrees with your rationale, that can be a problem because it looks like it's all post hoc and kind of just made up in the dispute at that stage.
Yeah, and as we know, attempts to write something up after the fact are not usually given a lot of credibility by a court or a board.
Exactly. Now, Fred, another thing I see all the time is people develop good relationships with a repeat customer, contracting officer as well, or the agency, or they have a long-term contract, that kind of thing. And they just fall into a pattern of, well, it's not a big deal. Joe, Mary, whoever it is a good, friendly person, and I'm not going to have an issue here because they would never do something like that to me. Have you experienced situations where that's not necessarily the case in terms of what might come wrong from that mentality?
Well, what comes wrong is that your great relationship may disappear when they get a different job, someone else comes in, or maybe more likely, a year later, there's an auditor who's looking at things and doesn't start with that background and certainly doesn't start with that relationship. We had a situation once where that very thing happened. There was a question about whether the folks who were performing the contract met the requirements stated for job experience, educational requirements, and so on. And they didn't meet what was in the contract. They did meet was in some other documents, fortunately, but they were really not contractual documents. The contracting officer was fully aware of all of this, but then they changed. The new contracting officer basically had a lack of backbone, and the auditors came in, and DCA challenged all of that. You want to have it in writing, you want to have it nailed down.
Absolutely. And I think even in the writing thing, if we talk about best practices, how to do this, we talked about emailing the contracting officer to confirm, that kind of thing. I think one of the best ways I've ever seen it done, and it saved a contractor from a very big dispute, essentially, under a 10-year contract, that kind of situation, very, very long term, the technical team and the contractor had kind of moved in a different direction, and everybody knew what was going on, and the contracting officer was friendly. No issues whatsoever. But then when personnel changed, the new contracting officer said, well, why are we doing this? I don't see that in the contract. This seems like you're acting out of scope, right? All these kinds of issues. And they were able to resolve that simply by what a lot of people might view as throwaways, monthly reports on the contract. On the monthly reports, the contractor put in meeting minutes that described what was discussed at the meeting, what they all kind of did and said would be a good thing to do. No contracting officer statement of, I agree, I consent to the situation, but that was enough to kind of set things back to a normal operating relationship between the two parties.
And note note that when you do those regular meetings, monthly, weekly, whatever, that's also a very good practice. Keeps the parties together on what's going on, and of course, again, document. I think maybe this is really closing out our first session, and we probably should save the rest for the next session. What do you think?
Yeah, that sounds good to me, Fred. So we'll go ahead and drop, and we'll look forward to seeing everybody in the next session to talk about the next common mistakes that we see.
Sounds good.
This has been the PCI Practical Matters podcast. Thank you, everyone, for tuning in, and we hope you listen next time.